I wanted to welcome everybody here tonight to the LBJ Foundation's 2020 Liberty and Justice for All program honoring the Honorable Ruth Bader Ginsburg. In 1956, when 22-year-old Ruth Ginsburg entered Harvard Law School, she was one of just 9 women in a class of 500, and the school's dean invited them all to a dinner at his home. It wasn't really just a social occasion. The dean used it to ask the women, "Why are you at Harvard Law School taking the place of a man?" Nearly 65 years later, half of the law students are women. 36% of the state Supreme Court justices are women, including 18 female chief justices, and more than a third of the nation's federal judges are women, including Justice Ginsburg and her 2 female colleagues on the nation's highest court. And I have to say here parenthetically that as a person who covered the court when there were no women justices, to walk into that courtroom and see Justice Sotomayor at one end and Justice Kagan at the other and Justice Ginsburg near the center periodically really makes my heart joyful. Ruth Bader Ginsburg, after law school, did something even more remarkable than she's done as a judge. She quite simply changed the way the world is for American women. As a young lawyer, she led the fight in the courts for gender equality. When she began her crusade, women were treated by law differently from men. Hundreds, perhaps even thousands of state, local, and federal laws restricted what women could do, banning them from jobs, from getting loans, even from jury service. By the time Ginsburg donned judicial robes, she had worked a revolution. I, as a young reporter coming up in the male-dominated world of journalism in the 1970s, was one of the many beneficiaries of her work and her friendship, ultimately. I want to take just a moment here to tell you how I first met the future justice. The year was 1971. I was assigned, among other things, to cover the Supreme Court. And to say that I was clueless would be an understatement. Then one day I picked up a brief in a case called Reed v. Reed. It was a new sort of case back then, and it challenged a state law that treated men differently from women. At issue was an Idaho law that automatically preferred men over women as executors of estates. Well, I really didn't understand the argument that it was unconstitutional under the 14th Amendment guarantee of equal protection of the law because it treated men and women differently. I said to myself, I thought the 14th Amendment was passed to protect African Americans. It wasn't about women. Hell, they didn't even have a vote back then. So I flipped to the front of the brief and saw that the author of this brief was a Rutgers law professor named Ruth Bader Ginsburg. So I went to the phone booth in the press room, and yes, all my colleagues here, we had phone booths in the press room then. And I called her. An hour later, I emerged so stuffed with new information that I felt like a goose whose liver was ready to be served as foie gras. The long and short of it was, as she put it then, that the 14th Amendment says, quote, "Nor shall any state deny to any person the equal protection of the laws." And those words, any person, cover women as well as men. Tonight, we honor Justice Ginsburg and the concept of liberty and justice for all that she embodies. It's now my pleasure to introduce a former Supreme Court clerk who would go on to become special counsel for President Lyndon Johnson, the chairman of the LBJ Foundation, Larry Temple.
Well, it's my honor to echo Nina's welcome to all of you at this presentation of the LBJ Liberty and Justice for All Award. Let me tell you about the award. Lyndon Johnson's basic creed was epitomized in the following simple but insightful statement from his 1965 voting rights speech, when he said, "Our mission is at once the oldest and the most basic of this country, to right wrong, to do justice, to serve man." At his core, Lyndon Johnson believed that every citizen of this country should have the opportunity to enjoy the benefits and receive the protections that are fundamental to our democracy. That is what motivated him to pursue the 1964 Civil Rights Act, the 1965 Voting Rights Act, and the 1968 Fair Housing Act. That is why he championed the adoption of Medicare and Medicaid. That is why he sponsored the landmark legislation in education. That is why he established the National Endowment for the Arts and the National Endowment for the Humanities. That is why he insisted on the passage of the Clean Rivers and Clean Air laws, the laws expanding our national parks, and the myriad other environmental laws that resulted in historian Doug Brinkley labeling him as the equal of Theodore Roosevelt in preserving our environment. LBJ's belief in equality was the very foundation of all of the Great Society programs. Presidential historian Doris Kearns Goodwin said that no president since Abraham Lincoln comes even close to the achievements of LBJ in the pursuit of equal rights for everyone. The Lyndon B. Johnson Foundation created the Liberty and Justice for All Award to recognize and honor those individuals who, in their own way and in their own time, are carrying on the legacy of opening the doors of opportunity for all of our citizens. The woman we honor tonight has already written her immutable place in the history of this country. Ruth Bader Ginsburg has lived two remarkable and incomparable lives. In the first 20 years of her career, she was a renowned law professor and lawyer. In the 1970s, she was the preeminent lawyer in this country advocating for fairness. Nobody, and I truly mean nobody, in the history of this country has done as much for gender equality as Ruth Bader Ginsburg. For the last 40 years, she has indelibly planted her footprints on the judicial landscape of this country. Even with years of service still ahead, Ruth Bader Ginsburg has already written her way into the pantheon of the great jurists that have served this country. I can say with certainty that Lyndon Johnson would be enormously proud to have known we would be giving this award to her in his name. All of the trustees of the LBJ Foundation share that pride. We are honored to recognize this iconic champion of justice tonight. Thank you.
So I have to move on here. Paramount in President Johnson's vision for a great society was equality for all Americans. Among other measures in his quest for liberty and justice for all, he championed the Civil Rights Act of '64, banning discrimination based on race, color, sex, religion, or national origin, and the Voting Rights Act of 1965, which enforced the 15th Amendment to the Constitution by removing barriers to voting on the basis of race. Throughout her long career, Justice Ginsburg has dedicated herself to those same principles, as reflected by a few of her writings, which will be read here by three distinguished actors. Sunny Hostin, the Emmy Award-winning co-host of ABC's The View, Emmy Award-winning actress Holland Taylor, and Golden Globe-nominated actress Constance Wu. Please welcome them to the stage.
Good evening, everybody. It's very cool to be here. I'm going to be reading an excerpt from Women and the Law, a symposium introduction, Rutgers University, May 1st, 1970, delivered by Rutgers law professor Ruth Bader Ginsburg. In the United States, in very recent years, appreciation of women's place has reached the nation state. Activated by feminists of both sexes, courts and legislators are beginning to recognize the claim of women to full membership in the class people, entitled to due process guarantees of life and liberty and equal protection of the laws. But the distance to equal opportunity remains considerable. Some European countries, as slow to accord women the vote, have followed up more rapidly than has the United States the promise of an equal voice in societal affairs. The unfinished business of equality for women is gaining momentum. Thought and energy directed to it in the 1970s may contribute significantly to the healthy environment and society universally desired for the decades ahead. Critical to a brighter future is the continued development of activist but politically acute feminist organizations, groups dedicated to the principle of equality but possessing the pragmatism essential to a movement whose ultimate success requires broad popular support.
An excerpt from Brief in Frontiero versus Richardson, filed in the United States Supreme Court, January 12, 1973, written by the director of the ACLU's Women's Rights Project, Ruth Bader Ginsburg. Growing up in a society in which virtually all positions of influence and power are held by men, women believe that they belong to the inferior sex. Women who seek to break out of the traditional pattern face all of the prejudice and hostility encountered by members of a minority group. Worse than being discreet and insular, which for other minority groups at least has the advantage of fostering political organizing, women are separated from each other and therefore remain far distant from the political potential appellees ascribe to them. For women who want to exercise options that do not fit within stereotypical notions of what is proper for a female, women who do not want to be protected but do want to develop their individual potential without artificial constraints, classifications reinforcing traditional male-female roles are hardly benign. Benign legislative judgments serve as constant reminders that, in the view of predominantly or all-male decision-making bodies, life should not be arranged this way.
Excerpt from the dissenting opinion of Shelby County versus Holder, June 25th, 2013, written by Associate Justice of the United States Supreme Court, Ruth Bader Ginsburg. The Voting Rights Act became one of the most consequential, efficacious, and amply justified exercises of federal legislative power in our nation's history. Throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. The sad irony of today's decision lies in its utter failure to grasp why the Voting Rights Act has proven effective. Beyond question, the Voting Rights Act is no ordinary legislation. It is extraordinary because Congress embarked on a mission long delayed and of extraordinary importance to realize the purpose and promise of the 15th Amendment. For half a century, a concerted effort has been made to end racial discrimination in voting. Thanks to the Voting Rights Act, progress, once the subject of a dream, has been achieved and continues to be made. After exhaustive evidence gathering and deliberative process, Congress reauthorized the Voting Rights Act. It was the judgment of Congress that, quote, 40 years has not been a sufficient amount of time to eliminate the vestiges of discrimination following nearly 100 years of disregard for the dictates of the 15th Amendment, and to ensure that the right of all citizens to vote is protected as guaranteed by the Constitution, end quote. In my judgment, the court errs egregiously by overriding Congress's decision. Thank you.
I think this is the end of me anyway. Please welcome former White House Press Secretary and Special Assistant to President Johnson, distinguished journalist Bill Moyers.
Thank you, Nina. So when Mark Harpdegrove called to ask me on behalf of the foundation if I would pay tribute tonight to Justice Ginsburg, he had no way of knowing that the pump had been primed. 2 weeks from now, I will interview the Justice when she receives the Judith Davidson Moyer Spirit of Woman Award from Union Theological Seminary in New York, the oldest independent ecumenical seminary in the country, from whose board Judith recently retired. You never know at my age when the next interview you do will be the last. So in preparation for this interview, I began months ago to steep myself in the lore and legacy of Kiki Ginsburg. So nicknamed, I learned, because as an infant in Brooklyn, she earned a reputation for vigorous kicking. She later perfected that talent as a flaming feminist advocate. And she went on, as everyone here knows, to become one of our most influential figures of constitutional interpretation in our history. Notwithstanding the irony that the founding fathers excluded her from the Constitution, and not merely because she was from Flatbush. Wanted to be thoroughly prepared for this, I began scouring the literature, beginning with the biography Ruth Bader Ginsburg, A Life by Jane DeHart, then moving on to the New York Times bestseller, My Own Words, Ruth Bader Ginsburg, with legal scholars Mary Hartnett and Wendy Williams. Earlier this month, I gave up several nights of sleep to read the fascinating new book, Conversations with RBG, on life, love, liberty, and the law. Based on a 20-year friendship and running conversation between the justice and the legal journalist and scholar Jeffrey Rosen, who's also president of the National Constitution Center. I read all of Nina Totenberg's interviews, including the 31 she's done already this year. And I have, of course, reviewed a score of Justice Ginsburg's notable briefs, both affirming and dissenting. And in the next 2 weeks, I expect to gain access to all of the trash collected behind her house by the Federalist Society. But a funny thing happened in the course of my preparation. I found myself, literally unaware of this event, I found myself marking at the bottom of the briefs, in the margins of the books, on Nina's interviews, the initials I scribbled, LBJ/RBG. Sometimes it was just the opposite, RBG, LBJ. Each, for me, came spontaneously as a point of convergence, an aha moment, a connection between Lyndon Johnson's presidency and Ruth Bader Ginsburg's opinions and arguments before and on the court. It was amazing, the common interests, the comparable values, the kinship of convictions. They were, of course, of different generations, born 25 years apart. RBG made her first oral argument before the Supreme Court as an advocate just 5 days before Lyndon Johnson died at his ranch in Texas. It's unlikely, as an old and young adult, they ever met. And yet, in so many ways, they wove similar patterns in the tapestry of democracy. One through politics, the other through the law. Now, when Mark called me to ask me to do this tonight, I didn't tell him that I'd done all this research already, but I did tell him that because I had been looking at some of her briefs, I had a story to tell him, and I wouldn't tell it tonight. This is not exactly the speech I intended to give, but everybody else has said the brilliant things I wanted to say anyway. But I told Mark this story, but I said I wouldn't tell it tonight. I told him of an event. It had been inspired by the brief that Justice Ginsburg wrote on the famous Voting Rights Act when in 2013, the 5 conservative members of the court declared unconstitutional the key provision striking down preclearance, as we heard earlier. What I told Mark is that late on an evening in June of 1964, I remember it so well because I was a few days before my 30th birthday. Before leaving the White House to go home, I delivered the president's night reading to his bedroom in the mansion. As I walked in, he was getting a massage. 10 o'clock it was at night. 10 o'clock news on WTOP was on. He was lying on his stomach. His chin rested on the fingers of his hands, but with one hand he shushed me as I entered the room. Shh, he said. He was looking up at the television screen on the other side of the bedroom, and there was, I think it was Roger Mudd, delivering an update from the steps of the Capitol on the filibuster that the Dixiecrats were waging with fierce intensity to try to preserve segregation now, segregation tomorrow, segregation forever. They were filibustering the Civil Rights Act of 1964, and they were determined to kill it by speech. They were desperate. And the president was getting this update on the latest development on this June day. It went on for 60 days, the filibuster. Right after that report, a filmed statement by Martin Luther King came on from some church somewhere in the country. The president is listening. Shh, he says. I just want to leave the pile of night reading and go home. He says, shh, wait. He says, he's quite a preacher, isn't he? I said, yes, sir, he is. I just today read one of his very terrific speeches, the baccalaureate he had given at Wesleyan University a few weeks earlier at the end of May. What did he say? The president asked me. He said, the arc of history is long, but it bends toward justice. He said that, the president said. He said that. Then he motioned me over to the massage table, asked me to lean down, and I did. And he said, not necessarily. It's not inevitable. It ain't going to happen. And he said ain't, I apologize, but he said ain't, unless we push. Because he said someone on the other side is always pushing back on the ark to reverse its course. Now he said, you get King on the phone. Tell him he's got to get up there to the Hill and tell all our friends in the Senate we got to shut off that goddamn filibuster and call the vote. Do you hear? I heard. I didn't call King on the way home. I called Hubert Humphrey. Senator Hubert Humphrey of Minnesota was managing the floor fight of the Civil Rights Act, and he was in regular contact with Martin Luther King and his lieutenants. I don't know if he reached King, but I do know that on July the 2nd, the arc of history landed at the point on his desk when his pen touched the parchment of the Civil Rights Act that became the law of the land. As I say, I told Mark this story, but I wasn't going to repeat it tonight because he duly gave me 5 minutes for this talk, and he said Larry Temple and the board would fire him if Moyers went overtime. So start packing. What's this got to do with Ruth Bader Ginsburg anyway? She was only 33 when we passed the Civil Rights Act, 34 when a year later we passed the Voting Rights Act, just beginning her long and illustrious career. And of course, it took the course of gender, women's issues, and ours had taken the course of civil rights, but they all grew out of the same womb of human rights. So I was going to honor Mark's injunction and save his job. Until today, I changed my mind. This morning, Judith and I went over to the National Museum of African American History and Culture. We walked past the exhibits, panel after panel. I'm sure most of you have been. If you haven't, go. Slavery's horrors, the reign of terror, the courage revealed by those who resisted, and the political betrayal by the first Johnson White House and by the Supreme Court that began to back away and back against and bend back the arc of history on issues of equality. We were walking there, and I was thinking about the arc of history and what the president said. You push it, they push back. You push it, they push back. We're in the pushback era now, the third great backlash to the struggle for human rights for blacks and women. And I remembered that line in Justice Ginsburg's incredible, scathing dissent of the 5 conservative members of the court who just gutted the Voting Rights Act 48 years after it had been passed and after it had been renewed under the two Bushes and Ford and a fourth time. And I stood there for a moment, sat there for a moment, and I thought of the glorious symmetry that we would sense in this room tonight when the family and friends of the second President Johnson and a living Supreme Court justice still pushing the arc forward. And I thought I had to tell you that story. The family and friends of one honoring the career and genius of a living Supreme Court justice who put her lean but mighty muscles on that arc as a young legal advocate and has kept pushing ever since. So there are scores of LBJ, RBG in the margins of the material I've been reading and underlining for that interview at your event, Judith. For example, Justice Ginsburg once defined affirmative action as endeavors to make the equality ideal more aspirational. I think she said that in Fisher versus the University of Texas when she said, if a University of Texas wants to have a modest affirmative action program, I think that's great. It's their business. I thought when I read that in the brief I was underlining of what President Johnson said at Howard University in 1965 in one of his most controversial speeches. Quote, "You do not take a person who for years has been hobbled by chains and liberate him, bring him up to the starting line of a race and then say to him, you're free to compete with all the others, and still justly believe that you've been completely fair. It is not just enough to open the gates of opportunity. All our citizens, men and women, black and white, must have the ability to walk through those gates. And this is the next and the more profound stage of the battle for civil rights." That was said 54 years ago. For both the justice and the president, equality became a battle of stereotypes and unconscious bias built into the systems and institutions, into, yes, law and tradition. She took on the case, as I think Nina was referring to, of Stephen Weisenfeld, whose wife died in childbirth. Stephen vowed he would work only part-time until his son was in school full-time. So he applied, though this is not the Idaho case. He applied for the Social Security benefits that he thought were available when a wage earner dies and leaves a child in the care of the surviving parent. But he was told by Social Security, Mr. Wiesenfeld, that benefit is a mother's benefit, and you are not a mother. As his advocate, RBG won a unanimous decision from the Supreme Court that put an end not only to the discrimination, but to the stereotype. LBJ, too, battled not in arenas of abstract ideas, but for real life people. Human beings with names, feelings, and needs. The people, as James Taylor sang about tonight, who are right in front of you. In 1964, as I was saying, reactionaries in Congress, many of them his old colleagues, if not his old friends, tried to exempt private business from the proposed Civil Rights Act, requiring an end to discrimination by any business making a profit from serving the public. The president wouldn't budge. I heard him time and again argue that when Helen and Gene Williams, a couple on his staff, drove across the South from Washington to Austin and back, they were more likely to find a motel with a room for a dog than one with a bed for people of color. But I thought at the museum today, if they'd gone through Humboldt, Tennessee, they would have found a red sign there that said, Booker T Motel, everyone welcome. But they were few and far between. For her part, Justice Ginsburg still writes and talks about the individual men and women whose lives have changed because the law was changed. Gwendolyn Hunt, who insisted a trial by her peers meant women on the jury. Sally Reed, who objected to that Idaho law that gave men preference over women in managing the estate. And Lilly Ledbetter, cheated by a huge corporation out of the wages she was due, who only wanted to be paid the same as men doing the same kind of work. Both the politician and the justice made America more just and made it more embracive. That's her term. She loves the term embracive. Embracive of the abandoned, embracive of the left out, and embracive of those left behind. Women, former slaves, Native Americans, embraced not grudgingly, but with open arms, becoming we the people thanks to progressive politics, constitutional amendments, and judicial interpretations. In doing this research, I came across a video of the Justice's last appearance as students at George Washington University. She told them that America's greatness came from welcoming all, from the idea that we are many, but we are one. And when I went home that evening, I looked on YouTube and found President Johnson sitting at the base of the Statue of Liberty in New York Harbor, Lower Manhattan behind him on one frame, and out of the other frame, Ellis Island. And what was he doing? Signing the Immigration and Naturalization Act of 1965. Signing it. And saying to everyone gathered there, our beautiful America is because we have opened our doors to so many, bringing new sources of ideas and culture. It really is, isn't it, when we put everything else aside? It really is about liberty and justice for all. Otherwise, democracy is a lie. But it's not a lie. Even as adherents of social Darwinism and sociopathic authoritarianism are trying to shut it off, finish it down, turn the very idea of one person, one vote into a winner-take-all society. But in different times and different ways, RBG and LBJ were on the right side of the oldest story in America, driven home by the exhibit at the museum today. The struggle to determine whether we, the people, are indeed a metaphysical reality, one nation, one indivisible, or merely an economic casino masquerading as piety and manipulated by the powerful and the privileged to serve their advantage at the expense of others. It is liberty and justice for all, or we're living a lie, and we're not living a lie. Now please welcome to the stage Linda Johnson Robb, Lucy Baines Johnson, and this evening's honoree, United States Supreme Court Associate Justice Ruth Bader Ginsburg.
Bring back the podium. I can make it smell.
See you at dinner. Sit down.
I'm gonna make some more.
Ma'am?
I'm gonna make some opening remarks.
Please, by all means.
But they took away the podium.
Oh, you want to sit? Why don't you sit? Yeah. I think they want you to sit here, ma'am. Is that okay?
What was in that one?
Yeah. Well, congratulations, Madam Justice. This is a wonderful night for me. I get to talk to you, and I've been fired by Bill Moyers. It really doesn't get any better than that. We are delighted to honor you as our Liberty and Justice for All Award winner.
And wasn't it a treat to listen to Bill Moyers? I think you agree. The extra minutes he took.
It was worth my job.
Yes. Yeah. Well, I'd asked them to return the podium so I could say thank you for this award, but the podium does not seem to be in sight, so I will say thank you sitting down. Receipt of the LBJ Liberty and Justice Award is for me a huge honor. It places me in such good company. LBJ massively moved the USA closer to the pledge of liberty and justice for all. Programs his administration initiated under the ambitious title, The War on Poverty, aimed to portray the USA as a people who value the dignity and potential of every human being. Key components of that program remain in place today, including Medicare and Medicaid, the food stamps program, the Jobs Corps, VISTA, the Federal Work Study Program for college and university campuses, Head Start, federal subsidies for school districts with a large share of impoverished children. Giant strides during President Johnson's tenure, as you just heard from Nina Totenberg and Bill Moyers. LBJ engineered the passage of the Civil Rights Act of 1964, which broadly banned discrimination on the basis of race and included sex as well in Title VII, the Act's employment chapter. The next year, he successfully advanced the Voting Rights Act of 1965. Those measures were costly. President Johnson knew they would end the South's fidelity to the Democratic Party. But the legislation was overdue, and he was determined to get the bills passed. The motivating ideal: we the people should embrace all who dwell in our fair land, not just white men of means. It is an ideal still resisted in some quarters, but we have reason to believe it will endure, because as Bill Moyers said, it is essential to a true democracy in today's world. My appreciation for selecting me for this award. My thanks to everyone involved in planning tonight's events, and to all gathered here for attending. I hope you are enjoying and will continue to enjoy the evening. Thank you, thank you.
Justice Ginsburg, Nina Thunberg referred to the inauspicious welcome that you got when you enrolled in Harvard Law School in 1956. But I wonder what you had in mind for your life, what you imagined for your life when you graduated from Columbia Law School in 1959.
I anticipated I would get a job in a law firm. As it turned out, even though I had rather good grades in law school, there was not a single firm in the entire city of New York willing to take a chance on me. My dear colleague, first woman ever to serve on the Supreme Court, Sandra O'Connor, had a similar experience. She got her first job by volunteering to work for free for a county attorney and said, after some months, if you think I'm worth it, you can put me on the payroll. That's how the world was. But Justice O'Connor made a remark. It's certainly true of her life and mine. She said, suppose we'd been born into a world where there was no discrimination, no closed doors. Where would we be today? Today, we would be retired partners from some large law firm. Since we didn't have that opportunity, we had to find another path. And where did it lead? To the United States Supreme Court.
In the short film that we saw in the opening, you said, relating to the struggle for gender equity in the 1970s, you referred to today's times. You said, we may be in trying times, but think of how it was. But I wonder, when you were waging that battle in the 1970s, if you were to look forward almost 50 years, would you have thought that we would have progressed further than we have today?
We have come a very long way. When, in the beginning of the 70s, the statute books of the states, the U.S. Code, were riddled with gender-based differentials, which were not thought of as discriminatory. They were thought to operate benignly in women's favor. It's in one case that Bill Moore has mentioned, Gwendolyn Hoyt's case, women were called to serve on juries. That was thought a favor to women. After all, they were the center of home and family life, so why bother them with jury duty? But jury duty is not only a right, it's an obligation of citizenship. And if you are not needed to participate in our system of justice, you are expendable. You are less than a full citizen. So my job was to get the court to see that all these differentials did not operate benignly in women's favor. They ranked women as subordinate. And that was the mission, to get rid of all the explicit gender-based discrimination written into the law. That job was done in the space of 10 years. So if you take out the codes of the states or the federal government, you will not find gender-based differentials. What remains, and what's harder to get at, is there was a reference to unconscious bias. Women of my generation, every one of them had the experience of being at a meeting, saying something, no comment. Then, some minutes later, a man will say substantially the same thing. And people react to it, and they say, good idea. That unconscious bias. You hear a woman's voice and you have a lowered expectation. My best example of that is the symphony orchestra. In my growing up years, I never saw a woman in a symphony orchestra. The New York Times critic Howard Taubman swore you could blindfold him, and he could tell the difference between a woman playing the piano, violin, and a man. They put him to the test. He was all mixed up. A woman was playing, he said it was a man, and he admitted, yes, he had had a certain lowered expectation when he saw a woman. After the blindfold, someone came up with the bright idea of dropping a curtain between the people who were auditioning and the judges. And that dropped curtain led to an almost overnight change in the composition of our symphony orchestras. I was telling this story once at a music festival, and a young violinist came up to me and said, "You left something out." What did I leave out? You left out that we audition shoeless, so they won't hear a woman's heels coming on the stage. But that's something that the law alone can't get at. It takes a consciousness that exists and a readiness to get past it. So I'd say that's number one, unconscious bias, and perhaps on the same level is the work-life balance, which I thought in the electronic age would be easier to overcome. Because if you're a lawyer, for example, you have the entire law library at your fingertips wherever you are. But firms have not yet been sufficiently accommodating. There's been vast improvement. I think of my last year of law school at Columbia Law School. In that whole area of New York, there was only one nursery school. It would take a child for 3 hours, 9 to 12, or 2 to 5. My daughter is now a distinguished professor at Columbia Law School. When she started working at Columbia many years ago, there were already dozens of full-day daycare centers in that area. So it's improving. One of the hurdles for me getting a first job, is I had a 4-year-old child when I graduated from law school. And if a firm were willing to take the chance on a woman, a mother, no. Today I'd say every one of my colleagues has had law clerks with children. And so it's no longer considered the impediment that it once was. So the large job of getting rid of the explicit gender-based barriers has been done. Unconscious bias, work-life balance remain to be grappled with.
Madam Justice, your mother-in-law gave you advice on your wedding day that you have said has been instrumental in your life. She said, in every good marriage, it helps sometimes to be a little deaf. You've applied that notion to your tenure at the Supreme Court. When a thoughtless or unkind word is spoken, you've written, best to tune out. Reacting in anger or annoyance will not advance one's ability to persuade. So how do you best practice the art of persuasion as a Supreme Court justice?
By giving reasons why. Unlike members of the legislature, judges have to explain their decisions. And in that process of reasoning why, you're aiming to, your first audience is your colleagues when you circulate your opinion. Every time I circulated dissent, I'm aiming for that, can I get that 5th vote to make a majority? It's true that it rarely occurs, but it does occur, that the persuasiveness of an opinion draft will switch what was the dissent to majority opinion. And I had that heady experience some years ago when I was assigned by a senior colleague to write a dissenting opinion just for the two of us. So the vote at the conference was 7-2. In the fullness of time, the opinion came down 6-3. But the 2 had swelled to 6, and the 7 had shrunk to 3. So that is the aim. It's the reasoning when you explain your position. This is why I think the judgment should go this way. That's our principal tool.
In witnessing you and your colleagues, it's very clear that civility is the hallmark of the Supreme Court. It defines its culture. Despite your disparate views on things, you respect one another. But civility is manifestly lacking in American society today. How does America become a more civil society? Would it benefit us all to become a little more deaf?
Let me say something about civility at the court. It is the most collegial place I have ever worked. One symbol of it is every day before we sit to hear cases and every day before we confer on cases, we go around the conference room. Each justice shakes hands with every other. And that's the way of saying, yes, you circulated a pretty spicy dissent yesterday from my excellent majority opinion, but we're all in this together, and we know that the institution we serve is ever so much more important than our individual egos. So to make it work, we have to not just tolerate, but genuinely appreciate each other. Now, we've seen a high degree of polarization in recent years. Yes, that's true. But if you think back to 1993, the year that President Clinton nominated me for the good job I now hold for 27 years, I had spent 10 years of my life helping to organize and then superintending the ACLU's Women's Rights Project. And I was one of 4 general counsel to the ACLU. The vote for my confirmation was 96-3, and no one raised a question about my ACLU affiliation. Not one. In the next year, when President Clinton nominated Stephen Breyer, it was the same way. Overwhelming approval of the nomination. My hope is that someday there will be patriots on both sides of the aisle who are determined to stop the dysfunction we are now experiencing and who will decide that their institution of government should work for the benefit of all of the people.
What is your greatest fear for our country as we enter a new decade?
That is the fear, that this polarization will continue, and my greatest hope is that it will end. So when you think back to how it was in 93, the person who was my biggest supporter on the Senate Judiciary Committee was not the then chairman, although the chairman was certainly in my corner. It was then Senator Biden. But my greatest supporter was Orrin Hatch from Utah. And Strom Thurmond gave me a supply of Strom Thurmond keychains, which has lasted until last year. So I know how it could be, and I hope it will be that way again.
Is there a catalyst for greater unity, in your view?
I think it takes determined people, as I said, on both sides of the aisle, to say, let's get together, let's stop this, let's work for the benefit of all who compose we the people.
Madam Justice, as you look back on your career, if you could choose one case, either one that you've argued for the Supreme Court or rendered an opinion on as a justice on the Supreme Court that you would want to be most associated with in history, what would it be?
You know, I've written hundreds and hundreds of opinions. First, I was a Court of Appeals judge for 13 years before the appointment to the Supreme Court. So it's the question you pose is a little bit like asking me which of my 4 grandchildren and 2 step-grandchildren is my favorite. And I can't single out any one case, but 2 of my dissenting opinions that were mentioned tonight, the Shelby County decision that took the heart out of the Voting Rights Act, and Lilly Ledbetter's case. For a majority opinion, I'd say the Virginia Military Institute case. It had an informative title. It was United States against Virginia. The federal government was suing the state of Virginia, saying you can't make an educational opportunity available to members of one sex only. A few years ago, I went to VMI to celebrate the 21st anniversary of the decision, and everyone is so proud of the women cadets. And the faculty saw the benefit immediately because they knew they could upgrade their applicant pool if they included women. But these women, they're there for the rigorous training. They want to go through the rat line. They want to live in the same Spartan quarters, but they also want to be engineers, nuclear scientists. And the decision in the VMI case was, there were only 8 justices sitting, so it was 7-1, and Justice Scalia was the sole dissenter. He predicted that the school admitting women would spell the end of the school. Far from it. The school is in the best shape it's ever been today. So my husband's comment on that decision was, well, it took you 20 years to win the Wertheimer case, but you certainly did. You finally did. What was Wertheimer? It was about 2 schools in Philadelphia for gifted children. One was called Central High, and the other Girls. The titles told the story, Central and Girls. The Central High School had much better science and math facilities, infinitely better athletic facilities. And there was a young woman who wanted to be admitted to Central. The federal courts, the district judge, the trial judge decided in her favor. That was reversed on appeal 2-1. So at that point it was 2-2 in the federal judges. Supreme Court automatically affirmed the decision because the Supreme Court was divided, evenly divided. So that case in the 1970s ended in a division, in a tie, was a clear winner by 1996 when the VMI case was decided.
This may be just as challenging a question, but what accomplishment in your remarkable career gives you the greatest pride?
I suppose that I was lucky enough to be part of the revived feminist movement. Women had been saying the same things that we were saying in the 70s ever since Abigail Adams. But society was not yet prepared to listen. Even in the 60s, in the 70s, there had been a sea change in the way people were living. And I think of my own family. My daughter was born in 1955, and I was one of the few working moms in her grade school class. My son was born 10 years later in 1965, and it is not at all unusual to have a two-earner family. So I saw the law as catching up to a change that was already occurring in the larger society. Society had changed, so the law kind of put its imprimatur on that change. That started with the way people were conducting their lives. For one thing, women had many more years without child care responsibility because people lived much longer than they once did. And then inflation helped too. Because if you wanted to give your children opportunities, you needed a second income. And then the feminist movement was revived, not just in the United States, it was all over the world. I think it was 1975, the UN declared that International Women's Year. So I consider myself tremendously fortunate to have been alive and a lawyer when society finally was ready to recognize women as persons equal in citizenship stature to men.
Madam Justice, we thank you for being here. Moreover, we thank you, to borrow from my friend Bill Moyers, for helping to bend the arc of justice. Thank you so much.